Hello, my name is Chris Lewis. This is my presentation on the history of NCAA Supreme Court cases. I chose this topic because I'm a sports media major, yet these two cases have a lot to do with the sports economy and just how the business is going in general with college athletics. So the two cases I'll be talking about today are the NCAA versus Board of Regents of the University of Oklahoma, which took place in 1984, and the Murphy versus NCAA case, which just finished this year but was started last year. Some common themes and topics are broadcasting rights, states' rights, and betting. In the NCAA versus Board of Regents, this is a little background that's important. It's important to understand what the Sherman Antitrust Act is, which was passed in 1890. The Sherman Antitrust Act was created in 1890 to control monopolies and restrictions that diminish free trade. Around this time, the Industrial Revolution was going on, and a lot of big corporations and industry was starting to rise in America. So it was important that Congress pass this law so that smaller companies and businesses could thrive and not necessarily be controlled by some of these big organizations that were starting to be formulated. However, in the 1950s, the NCAA began to regulate televised games after a study concluded that television views decreased stadium attendance. They wanted to do this to protect mainly the integrity of the sport, yet there was no real economic reasoning behind this decision. So in 1979, the College Football Association, or the CFA, was formed and began creating television deals for schools with the NBC. And the NCAA was going to punish these schools for working on such a deal. And this included schools such as the University of Georgia and of Oklahoma, who believed that they were getting sort of fixed prices for games. There was one game on ABC between Appalachian State and the Citadel, which actually they received the same amount of money as when Oklahoma and Georgia played each other. So two of the biggest schools in the nation made the same amount of money off of broadcast as two very insignificant schools in the NCAA. So as a result, the University of Oklahoma sued the NCAA for its decision. In the district courts, the NCAA was found for price fixing and limiting the number of games broadcasted. And the Court of Appeals agreed with their decision, yet were conflicted because of dissenting opinions thought that they had authority to create these regulations for the schools. Yet the Supreme Court agreed again with these two courts after the NCAA appealed twice. They said that the NCAA's policies restricted colleges from being involved in a competitive market, and that in general, the NCAA's agreement with its colleges was a joint venture, and they were not an authority in the market at all. And they also agreed with the NCAA schools that decreased attendance and increased television viewership did not affect the integrity of the sport in general, and that was a nonsense opinion. So basically, the majority opinion of the Supreme Court realized that colleges needed to have some sort of authority in negotiating their own contract prices for television deals to help create a competitive market. The only dissenting opinion was that of Justice White, who believed that there was non-commercial intent in the team's decisions, and they did not believe that Oklahoma was obtaining more profit and output in general. And obviously, as a result, the long-term result, we can see that he was wrong because college football teams have set up their own television deals, and programs such as Notre Dame and Texas started creating multi-million-dollar contracts with television agencies. Notre Dame has a big contract with NBC to broadcast all their games, and the University of Texas has the Longhorn Network on ESPN, both of these which help draw a ton of revenue for the schools. If you can look in this graph in the bottom right corner, it shows the per school per year averages for these television contracts, which range from $15 million to $20 million per school per year, which are absolutely insane numbers. And for the leagues and conferences in general, the total average results in around $200 million to $250 million for those conferences. Yet there has been a trend recently that college athletes are feeling underappreciated because of the results of these television deals. Moving on, though, in the Murphy versus NCAA case, this is about sports betting. And in 1992, Congress passed PASPA, or the Professional and Amateur Sports Protection Act, which was designed to combat sports betting in the states. In around 2011, New Jersey wanted to legalize sports betting to take advantage of potential lost revenue that they were having in the state, which they calculated to be around $600 million of potential revenue that they were losing. And so they passed the Sports Wagering Act in 2012, and subsequently were sued by the NCAA, the NFL, the NBA, the MLB, and the NHL. Coincidentally, the NFL, NBA, MLB, and NHL all want to legalize sports betting and create a fair system so that they can be benefited from that. Yet the NCAA in general was against sports gambling, as they wanted to protect their athletes and just the integrity of the sport in general. And many in the sports community believe that sports betting is kind of unethical. Originally, the case failed to reach the Supreme Court as the district and appeal courts sided with the leagues and saw the law as being negated by PASPA and just older state laws in New Jersey. However, New Jersey revised their law, repealing the older state laws that had originally kind of precluded the law from getting passed in the first place. Yet, upon further investigation with the courts, regardless of whether or not these older laws were repealed, they still thought that PASPA negated the law from taking place in the first place. New Jersey decided that they were going to send a statement to the Supreme Court arguing that they had legitimacy in regarding creating this law in the state, and that PASPA did not really have control over states to regulate its own gambling laws because of the Constitution. And the majority opinion actually agreed with New Jersey regarding this. They concluded that PASPA was unconstitutional because it took too much power away from the states to regulate its own gambling laws. Yet the NCAA tried arguing further that there was preemption because of PASPA already existing. Yet there was no preemption applicable because preemption regards personal motives and private actions rather than motives of the state. And the Supremacy Clause was not applicable because the court's making a decision on the state rather than an individual. The only dissenting opinion was that of Justice Ginsburg, who believed that the court had a desire to legalize sports gambling and that overturning all of PASPA as unconstitutional was excessive. I apologize for the typo there. There was definitely a lot of momentum for sports gambling being legalized because of the election of Donald Trump, who has spoken out on multiple times about how he wants sports gambling to be legalized. And in general, it has been such a topic of discussion with the rise of daily fantasy leagues and just overseas betting in general. Just the popularity in the States has grown so much that there was definitely a lot of momentum towards this decision. Yet the results of this case are proven themselves. Sports gambling is now authorized for all of the states because of this decision. And then states could also potentially challenge other federal issues, such as marijuana legalization at a state level. The conclusions of this case is that of all these cases, I would say, is that historically the NCAA has sought to control its revenue The organization has been against private industry for a while to preserve the integrity of its sports. However, with how big sports media has become, this idea is hard to protect. Now, college sports are one of the most watched and sponsored events because of how much revenue college athletics collect. In general, I think the NCAA has been on the wrong side of these decisions because they try to control so much instead of letting the colleges sort of dictate their own sense of revenue. And I think with these two decisions, you'll see even bigger television contracts with schools. It's only going to get bigger. And with the legalization of sports gambling, prior to this college football and college basketball season, I definitely think you'll see a lot of change in regards to how athletes are going to respond to sports betting. I think in the near future, there will be more cases in the Supreme Court regarding athletes and trying to get equal representation in the league. Recently, there was the O'Bannon versus NCAA case, which never made it to the Supreme Court, but that case showed that the NCAA was profiting off of the likeness of student athletes. And in that case, which didn't go to the Supreme Court, but the decisions made definitely had a large effect, as like certain video games and other products that contain the likeness of college athletes could not be used anymore or sold on a basis because there's so much money going to those things as well. So as the business of college athletics grows, I just think you're going to see athletes want to have more of a voice in terms of monetary kind of incentives. Yet it will be difficult to really see the economic reasoning behind those as they're students and they're getting so much benefit from the schools in general, and plus that they're not really creating a product they're not really representing a league or anything. They're just representing the school, and that the schools would have to pay them directly as an employee rather than a student. But overall, this is my presentation on these two cases. I hope you learned something, and thank you very much.